We'll hear argument first this morning in Case 08-1521, McDonald versus the City of Chicago. Mr. Gura.
Mr. Chief Justice, and may it please the Court, although Chicago's ordinances cannot survive faithful application of due process doctrines, there is an even simpler, more essential reason for reversing the lower court's judgment. The Constitution's plain text, as understood by the people that ratified it, mandates this result. In 1868, our nation made a promise to the McDonald family. They and their descendants would henceforth be American citizens. And with American citizenship came the guarantee enshrined in our Constitution that no state could make or enforce any law which shall abridge the privileges or immunities of American citizenship.
Of course, this argument is contrary to the slaughterhouse cases, which have been the law for 140 years. It might be simpler, but it's a heavy burden for you to carry to suggest that we ought to overrule that decision.
Your Honor, the slaughterhouse cases should not have any stare decisis effect before the Court. The Court has always found that when a case is extremely wrong, when there is a great consensus that it was simply not decided correctly, especially any constitutional matter, it has less force.
What injustice has been caused by it that we have to remedy? Meaning, states have relied on having no grand juries. States have relied on not having civil trials in certain money cases. They've relied on regulating the use of firearms based on us, the Court, not incorporating the Privileges and Immunities Clause in the way that you identify it. So in which ways has ordered liberty been badly affected?
Justice Sotomayor, states may have grown accustomed to violating the rights of American citizens, but that does not bootstrap those violations into something that is constitutional.
Mr. Chief Justice, and may it please the Court, under this Court's existing jurisprudence, the case for incorporating the Second Amendment through the Due Process Clause is remarkably straightforward. The Second Amendment, like the First and the Fourth, protects a fundamental pre-existing right that is guaranteed
would you
to the
comment on Justice Kennedy's question about whether that necessarily incorporates every jot and tittle of the federal right into the federal one, keeping in mind that with regard to trial by jury in criminal cases, there's a difference. It's non-unanimous juries. Why does this incorporation have to be every bit as broad as the Second Amendment itself?
Well, Justice Stevens, I think in that respect, the Sixth Amendment is a bit of an outlier.
If the answer is no, why are you asking us to overrule 150, 140 years of prior law when you can reach your result under substantive due process? I mean, unless you're bucking for a place on some law school faculty.
No, I've left law school some time ago, and this is not an attempt to return.
I mean, what you argue is the darling of the professoriate, for sure, but it's also contrary to 140 years of our jurisprudence. Why do you want to undertake that burden instead of just arguing substantive due process, which, as much as I think it's wrong, I have acquiesced in it.
Justice Scalia, we would be extremely happy if the Court reverses the lower court based on the substantive due process theory that we argued in the Seventh Circuit. And indeed, had the Seventh Circuit accepted our substantive due process theory, which was our primary theory in the court below, we might not be here, or perhaps we would be here in a different posture.
But that of this, too, that when you have the First Amendment or some of the other amendments, there's always a big area where it's free speech versus a whole lot of things, but not often free speech versus life. When it's free speech versus life, we very often decide in favor of life. Here, every case will be on one side guns, on the other side human life. Statistics, balancing life versus guns. How are federal judges, in your opinion, rather than legislatures in the states in a federal system, How are federal judges supposed to carry this out? I want to see where we're going.
Federal judges should carry this out in the same way that was announced in this Court's decision in Heller.
Well, Heller, I didn't think explained that with I was dissenting, though. I didn't think it explained it with total clarity, but that's a dissenter's view.
Heller stood for the proposition that some activities are within the core boundaries of a right, and so long as people wish to do something that is literally understood to be a part of the boundaries of the right, it is to be protected.
Let me be specific. Suppose Chicago says, look, by banning handguns not in the hills, not hunting, nothing like that, nothing outside the city, in the city, we save several hundred human lives every year. And the other side says, we don't think it is several hundred, and moreover, that doesn't matter. How do you decide the case?
We decide that by looking not to which side has the better statistics, but rather to what the framers said in the Constitution, because that policy choice was made for us in the Constitution.
Mr. Feldman?
Mr. Chief Justice, and may it please the Court, the Second Amendment should not be incorporated and applied to the states because the right it protects is not implicit in the concept of ordered liberty. States and local governments have been the primary locus of firearms regulation in this country for the last 220 years. Firearms, unlike anything else that is the subject of a provision of the Bill of Rights, are designed to injure and kill. And the very same features that make firearms valuable for self-defense, as the Court noted in Heller, also.
When is the last time an opinion of ours made that the test implicit in the concept of ordered liberty? It sounds very nice, but when's the last time we used it?
But to get back to Justice Breyer's point, which I'm not sure you answered, is your theory that you simply, it's not a question of is it in or is it out, but you're saying, well, what is in and what is out?
No, my answer to the question would be I think it's out, because all that shows is the framers.
So you think it's in or out, right?
I think the best argument is that it's out for this reason. When the framers.
I know your reasons. I'm trying to get you to take a position on whether or not you want us to not only pick and choose among which amendments are part of our abstract notion of ordered liberty, or if you want us also to take amendments that might be in and refine them and shave them off a little bit and say, well, this part of the amendment is in and this part isn't.
No, that's not the argument that we're making.
Okay, so your argument is all in or all out?
The very outset of your argument, Justice Sotomayor asked the question which, as I understood it, essentially said, what are examples of privileges and immunities that are being denied by the states, which denial would be remedied by following your proposal to overrule the Slaughterhouse case? And let's leave the Second Amendment out. Let's assume the Second Amendment's a wash. It's either going to be incorporated or not going to be incorporated to the same extent under either the Privileges or Immunities Clause or the Due Process Clause. Leaving this due process, the Second Amendment out of it, what privileges and immunities are now being denied citizens of the United States?
Well, apart from the Second Amendment right, which is being denied to people in the United States, by Chicago at least, there are other rights enumerated in the first 8 amendments that were thought to be the personal guarantees, as well as certain unenumerated rights, which were understood to be part of the.
What are examples of those? A jury trial in civil cases?
The jury trial.
And grand jury indictment. What else?
There's not much left, Your Honor. Those are the only 2 provisions of the Bill of Rights that have not been held incorporated under due process, which informs us that perhaps we should have the Second Amendment incorporated.